Welcome to the Personal Injury Law Show, viewers. My name's Tony Carbone, personal injury lawyer of many years' experience. Next to me, I've got Nunzio Tartaglia, partner in the law firm in compensation. Good day, Nunzio.
Tony,
how are you?
Very well.
And on the other side, I've got an up-and-coming superstar, Alice O'Kane. How are you, Alice?
Fine, Tony, and yourself?
Yeah, good. Welcome aboard, guys.
Yeah, thank you.
Yeah.
So, Tony, what's in the news this week?
What's in the news is the escalating violence in our streets, pubs, clubs, bars, all sorts of things. If you have a look at the number of incidents occurring in these nightclubs and out in the streets, the King Street region, apparently Bar 20 lost its licence recently, it's just astounding how many people have been beaten and assaulted and sustaining serious injuries. Now, what the angle I've got tonight is this, guys, that you've got these people that are getting assaulted and sustaining all sorts of knifings and slashings across the face and other nasty injuries. My angle is this: you got the victim that can sue, Alice, but what happens to the person that caused the damage?
Well, it's a variety of things, Tony. It really depends upon the approach taken by the victim and their lawyers, but they can be liable in criminal proceedings and in civil proceedings as well.
Okay. And Nunzio, what about the fact that once you get a judgment against you, what happens to the person, the perpetrator?
Oh, well, a lot of ramifications. You've got, obviously, you've got damages you have to pay, and that can be expensive for a lot of people.
But what if they've got no money?
Well, you can make them bankrupt. There's many means which you can put them in a lot of trouble down the track.
But more importantly, what happens is when you get a judgment against you, it stays on a register, the Credit Reference Association register. And what that means, Alice, is that you can't get a loan.
That's right.
The judgment's good for how long, Nuns?
15 years, I
Yeah,
believe.
15 years. So remember this: if you're out there, you had a bit to drink, and you have a foolhardy moment where you want to smack someone or whatever else you want to do, think twice, because it's going to have long-lasting effects. It will affect your career, will affect your social standing in the community, and all sorts of things. Bottom line, remember this: it doesn't go away. That 30 seconds of madness or 10 seconds, whatever it is, will last with you forever. Anyway, tonight's topic, viewers, is about supermarkets and occupiers' liability. We're going to talk about supermarkets. It's people that are falling in supermarkets, slipping, tripping, and other incidents alike. Alice, what's the situation what's the law in relation to this occupiers' liability?
Well, Tony, the law used to be, up until sort of about 15 years ago, that a plaintiff had to show not only that they'd slipped over on something in a supermarket, but they also had to show how long the substance had been on the floor. But since a case that was decided about 1994, now they have to show that the occupier or the supermarket didn't have an adequate cleaning system in place, and that whilst they slipped on something on the floor, it's as a result of the supermarket's failure to properly inspect or clean their premises.
Just on that issue there, Nunzio, to have to show how long something's on the floor, does that mean you've got to be shopping in a shop for hours? It's absolutely outrageous, isn't it?
Yeah, it is, but at the same time, look, that's the law. And look, this case of Coaches, which Alice referred to, is interesting, and I suppose I'll quickly tell you the facts of it.
We'll get to that in a minute, but I just wanted to say this. Does that mean over all these years, Alice, before Coaches come along, did a plaintiff have to show how long something was on the floor?
That's right, Tony. You had to prove to the court how long the substance had been on the floor, and that was obviously very difficult for plaintiffs, because if you'd only been in the shop 15 minutes, how could you possibly know how long the liquid or the grapes or whatever it was on the floor?
Does that mean that very few plaintiffs would have won in court?
It made it very difficult, that's for sure.
Did it? Well, a lot of these cases do settle out of court, don't they, Nunzio?
They do. Look, you've got public liability insurers, and they do like to resolve these cases because look, it's expensive for everybody, Tony. So
it's commercial, isn't it?
Look, it is a commercial element to it compared to like your work cover and TAC, jurisdiction side of things.
The thing is this: when you take these cases to court, you need to settle out of court for the simple fact that even as a plaintiff, if you win, you'll find that there's massive shortfalls in legal fees. So, as a rule, lawyers generally try and tell the plaintiffs, be reasonable, compromise your claims, because it is a lot cheaper to try and settle out of court. Look, let's turn to this case of Coaches. Tell us the facts as succinctly as you can, Nunzio.
This is a case in which Miss Coaches went to a Coles supermarket, got there, I think, about 9:10 a.m, shopping, went to one of the aisles, reached for some washing detergent. On the way down, slipped on some Pino Clean that was on the floor. And look, it was undecided how long it had been there for, but I think the evidence that came out was that it would have been there from approximately 8:30 onwards, from when the supermarket opened. The system they had in place before, I suppose, this day was that the manager inspected the aisles every day, or every half an hour for every day, and there was an employee who mopped the aisles once an hour. On this particular day, though, Tony, this didn't happen, and the
What,
court
the employee wasn't there?
no, the employee wasn't there, and the manager on the day didn't inspect the aisles as she was required to do, and that was ultimately the cause of the the injuries that sustained by Miss Coaches.
Is there anything else you want to add to the facts of that case, Alice?
Well, Tony, what I can say is this is a clear breakdown in the system of cleaning. As Nunzio has pointed out to us, there was a very clear system. Someone was supposed to be inspecting once an hour and mopping the floors as well. The employee didn't show up for work that day, so the mopping didn't get done. And also the manager obviously had other things on her mind and didn't stick to her duties either. And that results in exactly what happened. Liquid stays on the floor, no one notices, no one does anything about it, and you have a fall.
If you want to be suspicious, she was in the Pontyclean aisle. It was Pontyclean that was on the floor.
Yep.
What's to say she didn't drop it?
That's a difficult question to answer, Tony.
That was raised in the case, wasn't it?
It was raised, but it was accepted by the court that the plaintiff didn't cause that, and that it was on the floor before she got there. So it was accepted by the courts, and look, that comes down to evidence, Tony.
So the law as we know it, Alice, is that every case is decided on its own facts.
That's exactly right.
And also it's important that we know what the cleaning system is of each individual occupier, that is supermarket, store,
That's
etc. And then you've got to know whether they've implemented their own system. Is that correct?
That's correct. And it can really vary across the board in terms of what the cleaning system is and who's responsible for what duties as well.
Is it onerous on the occupier, Nunzio? Does that mean they've got to keep logbooks and records and things like that?
They do, because look, as you said, there's plenty of these cases going around, so they've got to be diligent with that. And look, I don't think it's unreasonable. You've got supermarkets with many people going through the aisles every day, so it's not too unreasonable.
Well, I'll tell you, I've got my own experiences in the supermarket industry. I was there for 9.5 years when I was studying, and there was a lot of instances. We used to keep logbooks. I don't want to mention what the chain was. It was a pretty big supermarket chain. They used to say to us young fellows, redcoats at the time, make sure you fill in the logbook, sign it. And I said on a couple of occasions, but I haven't swept, I haven't cleaned, sign the logbook. So it was a threat made to the individuals to make sure that you filled in the logbooks just in case there was incidents and they had to cover their tracks. What we're going to do is turn to the case of Harris too. This is another interesting case where the plaintiff failed, I think. Before we do that, we've got to go to a sponsors break. Viewers, stay tuned, don't go away. We'll be back very shortly. Thank you.